Thank you very much for coming. On behalf of the Hastings Democrats and myself, we worked real hard to get this together. I'm just going to turn it over to Professor Little to tell you a little bit about the format and guests and get it started. So thanks.
The show today, right, is not me. It's our two guests. Let me just get an idea here. How many people here are Hastings students? Wow. How many people here are not Hastings students? Not so many. Okay. And we got Channel 7 here, so if anybody doesn't want to be on TV, you should not get in their camera in. So the focus of this panel is, in some broad sense, the enforcement of marijuana laws in the state of California. But in a more narrow sense is the intersection between marijuana law and compassionate use, or medical marijuana, depending on how you want to define it. I'm sure most of you are aware that in 1996, Proposition 215 enacted something called the Compassionate Use Act of 1996. The beginning provision of that states as follows: the people of the state of California hereby find and declare that the purposes of the Compassionate Use Act are as follows. A, to ensure that seriously ill Californians have the right to obtain and use marijuana for medical purposes where that medical use is deemed appropriate and has been recommended by a physician who has determined that the person's health will benefit from the use of marijuana in the treatment of cancer, anorexia, AIDS, chronic pain, spasticity, glaucoma, arthritis, migraine, or any other illness for which marijuana provides relief. So that's the beginning of the medical marijuana use statute, which is, I think, part of the Constitution by dint of it being a Constitution. We couldn't have two better people to talk to us about this topic today. Joe Elford, who is seated to my immediate left here, in bio says staff attorney. Is it general counsel more appropriate?
It's chief counsel. Chief counsel
for something called Americans for Safe Access. Joe was a Yale Law School graduate, clerked for Vaughn Walker, who is now the chief judge of the Northern District of California here. He did some criminal defense work after that, and then has assisted in matters such as the DEA's denial of the latest petition to reschedule marijuana, away from Schedule 1 in the federal marijuana laws. Worked on the Ed Rosenthal case, which has to do with medical marijuana. And now, as I say, is the general counsel for this nationwide group called Americans for Safe Access. Joe Russinello here, further to the left, as always. But he's on your right. Joe Russinello is so well known that he has his own Wikipedia page, which I am now reading from. First, like many very talented lawyers, he was born in New Jersey. But I think most importantly, right, I think Joe Russinello is the only person in the history of the United States to have served as the presidentially appointed Senate-confirmed U.S. Attorney twice, with a gap in between of, 17 years. So Joe was the U.S. Attorney in this district from 1982 to 1990. He then went into private practice with the Cooley-Godwin firm and also served as the dean of the San Francisco Law School for about 5 years. And then was asked by George W. Bush to once again become the U.S. Attorney, and he has now served as the U.S. Attorney for the Northern District of California since the middle of 2007. And continues to serve in that capacity today. So he is in charge of the law enforcement on the federal side from San Jose all the way north to the Oregon border and east to sort of a line that runs somewhere through east of Contra Costa County and up through Sacramento. So it's a pretty big district. And there's some marijuana use in the northern part of that district. You know, he's a member of the American College of Trial Lawyers, the American Board of Trial Lawyers, the American Law Institute, the American Court, and probably one of the most talented lawyers to hold the office of U.S. Attorney in many, many years. So we're happy to have him here. We thought we'd start with him because, as you probably know, President Obama made a statement, whether it was anticipated or not, at a press conference a while ago, that things might change with regard to the federal enforcement of the marijuana laws in the medical marijuana use context. So we're going to ask Joe to start off. We're going to have the other Joe respond, and then we're going to have a little debate, and then we're going to have questions from you all. Okay? Thanks.
Thanks, Rory, very much, and it's good to be here. There's so much that I could say to you to establish my bona fides and credibility with all of you, but I'll start by a couple of the obvious things. And one is that when I was your age, I was a Democrat. When I was in law school at NYU, I was a Democrat, as I had been an active Democrat in college, working on the Kennedy campaign, Kennedy campaign in the 1960s. So that'll give you some context to where I'm coming from in terms of my roots, at least. And it seems to me that it's now been 40 years plus that I've been involved in law enforcement in one aspect or another, and almost at intervals of 10 years, we have a debate about the efficacy of marijuana use and whether or not it should be legalized and so on and so forth, and whether by coincidence or by choice, it seems to me that I always get called in those iterations of that debate to deal with the subject, and I'm happy to do that. I'm happy to do that because, quite frankly, in my professional career, I started in the DA's office. Well, I started as an FBI agent, but as a lawyer practicing law, I started in the DA's office in the late 60s. And young DAs in those days did prosecute base-level narcotics violations as well as other kinds of crimes. And so I can tell you that, unlike many of you who probably aren't even 40 years old yet, I've been looking at this problem, dealing with this subject for at least 40 years, because it's been on my plate as a prosecutor or certainly as a citizen. And so what we're dealing with today is not much different in terms of the discussion than the discussions that we've had, at least 3 other times in a very serious way over the last 40 years. And I think it's important for our present discussion and the issue of whether or not there are significant changes afoot here in terms of enforcement to put into context some of that historical perspective. We'll spend a lot of time on it, just a couple of words to keep in mind. And that is in the 70s, when the Controlled Substance Act was enacted and marijuana was identified as a Schedule I drug. It had only been with a couple of years of experience that the Congress acted. A couple of years experience in terms of the phenomenon of fairly substantial marijuana use. It came out of all places, and not surprisingly, the free speech movement and the anti-war movement in Berkeley. There was very little pharmacology and scientific data that was available at the time the act was, the Controlled Substance Act was enacted. But there was, by then at least, the establishment in the School of Pharmacy in Mississippi, this attempt to kind of get a better quantitative analysis of marijuana to find out whether it really did have any efficaciousness, whether it was really the harmful substance that people were saying it was, or whether it was the benign substance that organizations that as early as the 60s were advocating for its legalization were suggesting that it was. And it was a rather rapid, escalating effort in the early 70s for about a period of 4 or 5 years to kind of gather all of the scientists and medical practitioners and others who were interested in the subject to kind of come to some consensus as to whether or not this was really harmful or not. And the consensus was that it was harmful. It's not a consensus